May it please the Court, my name is Sondergeld Initial J, Solicitor of Legal Aid, appearing on behalf of Mr Stone. Your Honour, the Crown seeks to admit the following evidence. The oral testimony of Constable Overton, 200 grams of palladium found in Mr Stone's car, 300 grams of palladium and 500 grams of cannabis found at Mr Stone's residence. Your Honour, we respectfully submit that Your Honour should exercise your discretion to exclude each of these pieces of evidence. I will now address each of these pieces of evidence in turn. First, I will consider the oral testimony of Constable Overton. I draw Your Honour's attention to Section 420, subsection 2 of the Queensland Evidence Act 1977, and Your Honour, I seek leave to dispense with formal citations for the remainder of my submissions. In the circumstances before us today, that provision required Constable Overton to inform Mr Stone that a representative of legal aid would be notified if he intended to question him, and to do so as soon as reasonably practicable. Constable Overton failed to discharge this statutory duty, and it is submitted that he had no statutory grounds to do so in circumstances where he could not have been satisfied that Mr Stone was not at a disadvantage in comparison with members of the Australian community under Section 420, subsection 3 of the Queensland Evidence Act. Further, prior to questioning, Mr Constable Overton was required to allow Mr Stone to speak to the support person and ensure that the support person was present prior to questioning under Section 420, subsection 4, and this did not occur. It is submitted that the case law makes it clear that the unfairness must be balanced against the seriousness of the alleged crime and the magnitude of the risk that they will wrongfully be convicted if the evidence is admitted. I draw Your Honour's attention to the Crown against Swaffield, in which a confession was not admissible in circumstances where the procedural right to silence was not adhered to. It is submitted by failing to advise Mr Stone of his right to silence. This is a breach that warrants the Court exercising its discretion to exclude this confession. I will now turn my attention to the 200 grams of palladium found in Mr Stone's car. Your Honour, we submit that the public policy discretion should be exercised in respect of this evidence. As Your Honour would be aware, Bunning and Cross describes the operation of this discretion and that its purpose is to uphold society's right to insist that those who enforce the law themselves respect it. It is submitted that Constable Overton improperly exercised his power by searching Mr Stone's car without a reasonable suspicion as required by Section 31 of the Police Powers and Responsibilities Act. It is submitted that in order to lawfully search Mr Stone's vehicle without a warrant, Section 31 of the Police Powers and Responsibilities Act required him to reasonably suspect any of the prescribed circumstances set out in Section 32. Constable Overton purportedly exercised his power due to Mr Stone nodding when asked whether he had recently used drugs. However, it is submitted that this could not have been a reasonable suspicion in circumstances where Mr Stone was driving legally at the time of the index event. The drug test returned a negative result. Mr Stone made no comment regarding unlawful dangerous drugs in his car. He only nodded when asked if he had consumed drugs in the last 12 hours, which we submit could have meant anything, including prescription drugs. It is therefore submitted that Your Honour should exercise your discretion to exclude this piece of evidence for the purposes of preserving the public interest in the protection of the individual from unlawful and unfair treatment. I will now briefly address each of the 5 criteria set out in Bunning and Cross. Firstly, while there may not have been a clear disregard of Mr Stone's rights, Constable Overton, from his perspective, alleges that he lawfully exercised the search of the car. However, we submit that this search was careless and reckless in regards to Mr Stone's right for the reasons that we have previously set out. In terms of the potential affected accuracy of the evidence due to obtaining improperly, we concede that this is not an issue. As to the urgency of the situation, Constable Overton's conduct was not a genuine response to pressing circumstances, and there was no suggestion that evidence was going to be destroyed. He could have and should have obtained a search warrant. As to the nature of the charge, in respect of this evidence, it is minor, and in the interest of public policy, we submit that the police should be held accountable to conducting searches properly. In terms of the purpose of the Act, one of the purposes of the Police Powers and Responsibilities Act is to ensure fairness and protect the rights of the persons against whom police officers exercise powers, and to enable the public to better understand the nature and extent and responsibilities of police officers. It is submitted that exercising Your Honour's discretion to exclude the 200 grams of palladium found in Mr. Stone's car would be consistent with the purposes of the police powers and responsibilities, since if it was allowed to be included, it would not be fair to Mr. Stone or protect his rights, and it would not allow the public to better understand the nature and extent of the powers and responsibilities of police if they are able to arbitrarily and unreasonably avoid those powers. I will now turn my attention to the 500 grams of cannabis found at Mr. Stone's house. As Your Honour would be aware, in order for evidence to be admissible in court, it must be relevant to a fact in issue as set out in Goldsmith and Sandilands. Mr. Stone is charged under Section 9A of the Drugs Misuse Act for allegedly unlawfully possessing a relevant substance. Pursuant to the Drugs Misuse Regulation, cannabis is not a relevant substance. Therefore, the cannabis as evidence is not relevant to a fact in issue. Therefore, it should not be admissible. If Your Honour, in the alternative, does find that it is admissible, we submit that it should be excluded anyway on the grounds of the public policy discretion. This is submitted in circumstances where the police clearly unlawfully searched the house, they did not have a warrant, and the home was at no risk of concealment and evidence was at no risk of destruction. I will now again briefly address the 5 criteria. In relation to the deliberate disregard, the facts are clear that the officers did not believe that they could rely on any warrantless search exceptions. This is a clear disregard of the provisions of the Police Powers and Responsibilities Act. We can see that the accuracy was not affected due to it being obtained improperly. However, there was no urgency in relation to that situation. The nature of the offence was minor, and the purpose of the Act was breached, as we have previously addressed. In summary, Your Honour, it is submitted that each piece of evidence should be excluded, and in particular the 500 grams of cannabis should not be admissible because it is not relevant to a fact in issue. Unless Your Honour has anything further, that concludes my submissions.